You're a painter and you contract to paint a house, but before you can start the job, the house burns to the ground. Are you obligated to paint the ashes? Hi, I'm Michael Dorff, and I'm the Executive Director of the Lowell Milken Institute for Business Law and Policy here at UCLA School of Law. And in the next 2 minutes, I'm going to tell you when impossibility excuses contract performance and when it doesn't. Before we start, we have to think about 3 different but related scenarios: true impossibility, commercial impracticability, and frustration of purpose. I'll take those each one at a time. True impossibility does excuse contract performance. So the house burned down in my scenario, there's no way you can paint that house. The painter is excused from contractual performance. You don't have to paint the house. And you can think of a number of different ways this could happen. There's the destruction of the subject of the contract, like my house burning example, or you could imagine that there was a personal services contract and the person who was supposed to perform the personal services dies or becomes incapacitated, like you hire a surgeon to do your gallbladder surgery and before you're put under, the surgeon dies, the surgeon's excused from performance by death. And the third possibility there is government regulation. If performance becomes illegal, you're also excused. So you have a contract to sell advanced computer chips to China. The government then says, oh, it's not legal anymore to sell those chips to China. You're excused from selling the computer chips to China. Commercial impracticability and frustration of purpose, though, are different. It's much harder to get excused by either of those. Commercial impracticability is what happens when the contractual performance becomes much more difficult or expensive because of some event that was not reasonably foreseeable and was not your fault. So, for example, you had contracted to host a large rock concert, but 2 weeks before the concert date, there was a global pandemic, and all of your workers became very ill and couldn't come in. That is commercial impracticability. It's not reasonably practical for you to be able to perform the contract, and it's for a reason that you couldn't reasonably have foreseen and was not your fault. You're out of the contract there. But it's not enough just that the contract became more expensive to perform, that you found a better deal elsewhere, or that you're going to lose money on the contract. None of those will suffice to excuse performance under impracticability. Frustration of purpose is similar, but instead of performance becoming more expensive or difficult, it's the return consideration, what you're getting for the contract, that becomes worth a lot less, such that the contract is kind of pointless now. For example, you rented a room that overlooks a street where there's going to be a big parade the next day. You rented the room just for the 3 hours where the parade was going to go by. Then, for reasons you couldn't foresee and were not your fault, the parade was canceled. You can get out of the rental contract. So again, to sum up, true impossibility excuses performance, but frustration of purpose and impracticability usually don't. What's the most impossible situation you've ever experienced that you thought might have excused performance? Comment below and follow for contract law that actually makes sense.